Massachusetts has one of the most tenant-protective screening environments in the country, shaped by a strong consumer protection framework, broad fair housing protections, and an enforcement culture that actively pursues landlords who violate screening requirements. The governing framework includes Massachusetts General Laws, Chapter 186, the Landlord-Tenant Chapter, along with Chapter 93A, the Powerful Consumer Protection Statute, Chapter 151B, the Fair Housing Law, and FCRA. If you're screening tenants in Massachusetts, you're operating in a legal environment where mistakes carry significant financial consequences. Let's start with application fees, because Massachusetts has one of the most restrictive fee frameworks in the country. Under Massachusetts law, landlords are severely limited in what they can charge prospective tenants at the application stage. Landlords cannot charge an application fee. The only charges a landlord can legally collect from a prospective tenant before move-in are the first month's rent, the last month's rent, the security deposit, limited to 1 month's rent, and the cost of purchasing and installing a new lock and key. That's it. This means no screening fee, no credit check fee, no application processing fee, nothing. The cost of tenant screening must be absorbed entirely by the landlord as a business expense. This is one of the most restrictive fee structures in the nation and fundamentally changes the economics of screening in Massachusetts. The prohibition on application fees is actively enforced. Under Chapter 93A, Massachusetts's Consumer Protection Statute, a landlord who collects an illegal fee can face treble damages, attorney's fees, and court costs. Chapter 93A claims are powerful tools for tenants, and Massachusetts courts have a long history of imposing significant penalties on landlords who charge prohibited fees. The risk of collecting an application fee, even a modest one, far outweighs any benefit. Because landlords absorb the screening cost, maximizing the value of every screening report is critical. Use a provider that delivers comprehensive results: credit, criminal, eviction, and rental history in a single report at the lowest possible cost. The screening expense is a cost of doing business in Massachusetts, and building it into your overall operating budget is the only compliant approach. Criminal history screening in Massachusetts is restricted by both state law and local ordinances. Massachusetts does not have a comprehensive statewide ban-the-box housing law with the step-by-step procedural detail found in places like Washington, D.C. or Minneapolis. However, several important state-level provisions affect how criminal history can be used. Massachusetts reformed its criminal record system through the Criminal Justice Reform Act of 2018 and subsequent legislation. The reforms expanded expungement eligibility, improved the accuracy of criminal record information, and established the concept of sealed records. Landlords cannot consider sealed or expunged records in screening decisions. Massachusetts also restricts the use of criminal offender record information, known as CORI. Access to CORI is regulated by the Criminal History Systems Board, and not all criminal record information is available to landlords. Standard CORI reports available to housing providers show only certain categories of convictions, typically felony convictions and certain misdemeanor convictions within specified look-back periods. Pending cases and arrests that didn't result in conviction are generally not available on the standard CORI report. Boston enacted a local fair chance housing ordinance that adds requirements beyond state law. Under Boston's ordinance, landlords face restrictions on when they can access criminal history and how they can use it in screening decisions. Boston requires landlords to conduct an individualized assessment when considering criminal history, evaluating the nature and severity of the offense, time elapsed, evidence of rehabilitation, and the relationship to the tenancy. Boston's ordinance includes notice and opportunity to respond requirements when a landlord considers withdrawing an offer based on criminal history. Cambridge, Somerville, and other Boston area communities have been active in tenant protection discussions, and additional local criminal history restrictions are possible. Landlords in the greater Boston area should monitor local developments. CHUD's 2016 guidance on criminal history and disparate impact applies in Massachusetts. The state's diverse population, particularly in the Boston metro, Springfield, Worcester, and Lawrence, means that criminal history policies that disproportionately affect minority applicants face significant scrutiny. Massachusetts' enforcement environment is among the most aggressive in the country for fair housing, and overly broad criminal history policies carry substantial risk. Source of income protection in Massachusetts is well established and strongly enforced. Under Chapter 151B, the Massachusetts Fair Housing Law, landlords cannot discriminate against applicants based on their receipt of public assistance, including housing choice vouchers, known locally as Section 8, Social Security, disability payments, veterans' benefits, and any other lawful source of income. Massachusetts' source of income protection is one of the oldest and most actively enforced in the country. The Massachusetts Commission Against Discrimination, known as MCAD, investigates complaints and has pursued significant enforcement actions against landlords who discriminate against voucher holders. Fair housing testing is common in Massachusetts, particularly in the Boston metro, and organizations regularly send testers posing as voucher holders to identify discriminatory practices. Landlords cannot state that they don't accept Section 8 or vouchers in listings, phone conversations, emails, showings, or any other form of communication. Landlords cannot set income requirements that effectively screen out voucher holders when the voucher plus the tenant's income would cover the rent. And landlords cannot impose additional screening requirements on voucher applicants that aren't applied to all applicants. For credit reports, Massachusetts follows FCRA requirements for permissible purpose and written consent. The adverse action process follows both FCRA and Massachusetts' broader consumer protection framework. Given the prohibition on application fees, the landlord bears the cost of pulling the credit report and must still provide the standard FCRA adverse action notice if denying based on credit information. Massachusetts Consumer Protection Statute, Chapter 93A, adds an important overlay to the entire screening process. Under 93A, unfair or deceptive practices in business transactions are prohibited and can result in treble damages and attorney's fees. This means that virtually any screening practice that's deceptive, misleading, or unfair to applicants can be challenged under 93A, not just violations of specific screening statutes. The broad reach of 93A makes Massachusetts one of the highest risk states for landlords who cut corners on screening compliance. Massachusetts' fair housing protections under Chapter 151B are among the broadest in the country. Protected categories include race, color, religion, national origin, sex, sexual orientation, gender identity, disability, familial status, marital status, age, ancestry, genetic information, military status, and receipt of public assistance. The breadth of these protections creates a screening environment where virtually every applicant characteristic is potentially protected. The genetic information protection means landlords cannot consider genetic testing information or family medical history in screening decisions. This rarely arises in practice, but reflects the comprehensiveness of Massachusetts' framework. The military status protection means landlords cannot discriminate against current or former military members. Combined with SCRA protections, military applicants in Massachusetts have robust protections. MCAD actively investigates fair housing complaints and has broad enforcement authority, including damages, injunctive relief, civil penalties, and attorney's fees. Massachusetts courts have a long history of holding landlords accountable for discrimination, and the state's legal aid organizations, including the Massachusetts Law Reform Institute and local legal services offices, actively pursue fair housing cases. Massachusetts has a specific anti-retaliation provision that affects the screening context. Under Section 186 and related provisions, the state creates a presumption of retaliation if a landlord takes adverse action within 6 months of a tenant exercising a legal right. The statute establishes a clear and convincing evidence standard, meaning the landlord must present strong evidence to overcome the presumption. While this primarily applies to existing tenancies, it reflects Massachusetts' strong commitment to protecting tenants who exercise their rights. From a practical standpoint, Massachusetts has a tight and expensive rental market, one of the most challenging in the country for both landlords and tenants. Boston is the dominant rental market and one of the most expensive in the nation. The economy is driven by healthcare, including Massachusetts General Hospital, Brigham and Women's Hospital, Beth Israel Deaconess, and dozens of other world-renowned medical institutions, higher education, Harvard, MIT, Boston University, Northeastern, Boston College, Tufts, and numerous others, biotechnology and pharmaceuticals. The Cambridge and Kendall Square corridor is the global epicenter of biotech, financial services, technology, and government. Boston's rental market is extremely tight with vacancy rates consistently among the lowest in the country. Boston's screening environment is the most restrictive in Massachusetts due to the city's local ordinances. The combination of no application fees, criminal history restrictions, source of income protections, and Massachusetts' broad fair housing categories creates a screening process that requires meticulous compliance attention. Boston landlords must build their entire screening workflow around these restrictions. The student population in Boston and Cambridge is enormous. Hundreds of thousands of students attend area universities, creating massive seasonal rental demand. The September 1st lease cycle dominates the Boston market, with the majority of leases turning over on that date. Screening high volumes of student applicants with limited credit and rental history is a core challenge for Boston landlords. Cosigner and guarantor policies are standard practice and must be applied consistently. Cambridge, home to Harvard and MIT, has an extraordinarily expensive and tight rental market. Somerville, Brookline, and the inner suburbs share Boston's market dynamics and regulatory environment. Worcester, the state's second-largest city, has a more affordable market driven by healthcare, including UMass Memorial Medical Center, higher education, including Clark University, WPI, and College of the Holy Cross, and biotechnology. Worcester has experienced growth as remote workers, and Boston commuters have sought more affordable alternatives. Springfield, in western Massachusetts, has a more affordable market with a diverse population. The economy is driven by healthcare, including Bay State Medical Center, education, government, and manufacturing. Springfield has higher poverty rates than eastern Massachusetts, and a significant portion of the rental population receives housing assistance. Source of income protections are particularly relevant in Springfield's market. Lowell, Lawrence, New Bedford, Fall River, and Brockton have more affordable markets with diverse populations, including significant immigrant communities from Latin America, Southeast Asia, and Africa. Screening applicants with limited U.S. credit history and non-traditional rental backgrounds is common in these communities. The Cape Cod and Islands region, including Provincetown, Hyannis, Martha's Vineyard, and Nantucket, has a seasonal tourism market with extreme housing affordability challenges for year-round workers. Joint Base Cape Cod generates some military rental demand on the Upper Cape. Military presence in Massachusetts includes Hanscom Air Force Base, the Natick Soldier Systems Center, and various Reserve and National Guard facilities. The military population is relatively small compared to states with major installations, but military tenants have full SCRA protections and should be screened using standard military income verification procedures. One critical best practice for Massachusetts landlords: never charge an application fee, credit check fee, or screening fee of any kind. The prohibition is absolute. The penalties under Chapter 93A are severe, treble damages plus attorney's fees, and the risk is not worth any amount of fee revenue. Budget your screening costs as an operating expense and factor them into your overall rental pricing strategy. Another critical best practice: never state in any form that you don't accept Section 8 or vouchers. Massachusetts's source of income protection is among the most actively enforced in the country. Fair housing testing is regular and aggressive. MCAD takes source of income discrimination seriously and has a track record of significant enforcement actions. Train every person who interacts with prospective tenants. From the first phone inquiry through lease signing, that source of income discrimination is illegal. A third best practice: for Boston landlords, implement the criminal history screening procedures required by the city's Fair Chance Housing Ordinance. Build the individualized assessment into your workflow. Document your analysis for every applicant whose criminal history you consider, and provide the required notices and opportunities to respond. Keep thorough records. Your documentation is your defense if MCAT or a fair housing organization investigates a complaint. Massachusetts limits the security deposit to 1 month's rent. The deposit must be held in a separate interest-bearing escrow account at a Massachusetts bank, and the landlord must provide the tenant with a receipt that includes the bank name, account number, and amount deposited. Interest must be paid to the tenant annually or deducted from rent. The deposit must be returned within 30 days of the tenant vacating. Failure to comply with any of the detailed deposit requirements can result in the landlord forfeiting the entire deposit, plus treble damages under Chapter 93A. The strict deposit requirements and 1-month cap make thorough screening absolutely essential. Your financial protection against a problem tenant is minimal. The eviction process in Massachusetts can take months, and the legal consequences of screening violations are among the harshest in the country. Getting the screening right, within the significant restrictions that Massachusetts imposes, is the foundation of successful landlording in this state. For the complete guide to Massachusetts tenant screening laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our tenant screening law series.